May it please the court. I am Counselor Gilkerson, and under the rulings of the previous case, I would clearly display how sufficient physical force with intent or arrest was not applied to constitute a seizure, and why the petitioner's use of common law does not apply to this case, and therefore does not constitute a seizure. Now let's start with why common law does not apply to this case. Reason why, or why common law, the view of petitioner's common law does not apply to this case. Main reason is, for one thing, in Tennessee v. Gardner, it talked about relying on common law rule would be mistaken literalism that ignores the purpose of a historical inquiry. This basically means that definitions can change over time. I'd like to also add.
So, if they can change over time, then how can anybody predict what the law is going to be? Don't we conform our behaviors, either decide to conform to the law or break the law? But the reason that we know whether we're conforming to the law or breaking the law is because we have predictability that the law doesn't change, that the meaning doesn't change. So isn't there value in relying on those original definitions?
Yes, Your Honor. However, within the common law cases that are provided, these are all debt collector cases, and with that, they are very different from what we were dealing today. For instance, with specifically other cases that deal with gunshots, Monex v. Luna is where the petitioner was shot and was able to be physically restrained. Because the case does not put emphasis on the fact that she was shot, it puts emphasis on the fact that she was restrained, or more so killed. Similarly in Tennessee v. Gardner, when the 15-year-old boy attempted to jump the fence and got shot, that case also puts emphasis on the fact that he was restrained and was not able to walk away. I would like to also, within our case, we had within our case, it is very different, because when the petitioner was stopped, movement never stopped. As my co-counselor explained, she was able to steal a car, drive away, get to the hospital, and she wasn't seized until the next day.
Counselor, what would have constituted a seizure on that first day? What would have been necessary, using your definition? What would have been necessary to have happened for there to be a seizure?
She would have needed to be physically restrained, similarly to the Gardner case or the Molenex case. I would also like to point to Hadari D, where within that case, the petitioner was not seized until she was tackled, or he was tackled.
Counsel, may I ask you about Hadari D? And we talked about, I think your co-counsel addressed this in part, so bear with me. But in your opponent's brief, they claim that Hadari D confirmed that in common law, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. What do you have to say about that?
Would you rephrase that question, please?
Well, I'm just quoting from their introduction, which says they claim Hadari D stands for the proposition that, quote, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. And that's a 1991 case from this court. Do you think that was the, I think this court needs to follow that statement that mere grasping or application of physical force, whether or not it succeeded in subduing the arrestee, was sufficient?
The key part that he's asking there is whether or not it succeeded in stopping the person.
Your Honor, within that case, it says that the petitioner was not seized because when discarding the evidence, when the evidence was discarded, there was no seizure because he was not restrained. Not only not restrained, but also there was no physical force, or
So
there
you're
was no
saying-
sufficient physical force.
So you're saying, what RED actually helps you all?
I mean, yes, Your Honor.
I do have a question. It seems like Garner suggests that the definition, whether we're looking at seizure under the Fourth Amendment, or I think as your co-counsel suggested, there's a more general definition of seizure. Seems to me Garner is saying that the common law only really helps us in the context of a general definition of seizure, because if, as they say, if by means of applying deadly force, seeing a suspect by shooting him dead kind of brings the justice process to an end, at least as to that deceased individual. So you find that limiting the definitions that way is a help to you in what you're trying to pound here? I mean, you've taken the approach of dividing seizure, at least as I took it, into the under the Fourth Amendment versus seizure in a more general kind of common law approach.
Your Honor, I don't know if I entirely understand the question. Would you please rephrase that?
Well, let me ask it a different way, by using facts. Because he and I are trying to get the same place here. If the police officer, instead of shooting a gun, used his fist and hit the person, knocked him down to the ground, put handcuffs on them, and got one handcuff on, didn't get the other one on, and the person broke free and ran away and escaped, was there a seizure? Using your theory of the case?
No, Your Honor, because a reasonable person would not feel at liberty to leave.
So as long as you...
Because they...
Go ahead.
Because a reasonable person would not, because in this instance, according to the petitioner, they thought that these were carjackers. In this instant, this hypothetical that you were presenting, they know that they are officers, and they know, they're very well aware that they are trying to arrest.
Very good. Now let me go back then. So let's assume that she knew that this was a police officer shooting. Same facts as exactly that happened here, but from the perspective of the petitioners. So the petitioners believe that the she knew that the police were there. Let's assume that that's the case. Was there if that is the case, and was there a seizure then? If she knew that they're police officers and that she was hit by a police officer's bullet?
No, Your Honor, because it is there needs to be sufficiency along with restraining force.
And restraining force,
Or-
well, it's a pretty good restraining force.
The sufficient restraining force, my bad, sufficient restraining force, because as we've previously mentioned, she was able to very easily go free, and the cops did not pursue her until the following day. In conclusion, as my colleague, Counsel Archie, and myself have explained, the petitioner was not seized, and we ask you to keep the lower court's ruling.